Welcome to this presentation in which we're going to discuss the differences between grand juries and petit juries. This is a topic that comes up pretty regularly in the news. You may have wondered about how that all works, and so I think I will probably resolve most of your questions. Of course, if you have additional questions, you're welcome to let me know. I have never practiced, well, I shouldn't say never. I have not, as a general rule, practiced as a criminal attorney, so I'm not an expert in the area, but I'd be glad to tell you what I know and we can find the additional answers together. This is a topic that receives a fair amount of testing on our tests. It is something that we emphasize, and so probably a little bit more than you might expect. As a result, I wanted to give you some additional tools to help you make sense of this area. So we'll find really, in addition to this lecture, an important chart that will help you understand the differences. So we're going to go down to chapter 13, and you'll see the bottom is differences between grand juries and petit juries. So I'm going to open up this same document, and we're going to go through this pretty quickly. The information in this chart is all that you'll need to know for the test. And even there, you won't have to regurgitate every single fact, but you should be able to recognize these facts when you see them in a true, false, or multiple choice test. And you ought to be able to write intelligently about what a grand jury is and what a petit jury is and what the differences are between the two of them if you were to be given that, say, as an essay question. So let's get started. The big thing to keep in mind, the big difference is that grand juries deliver indictments and petit juries are the juries that handle the trial. They're the people that hear the evidence when we're actually in trial. So those are two huge differences. There's more differences than similarities between grand juries and petit juries. And so we're going to go through and kind of parse those differences. The first thing that you may notice about the names is that grand or grand jury suggests something big, and that the reason that it's called a grand jury or grand jury is because of the French origins of many of our words in the law. We oftentimes think about the law as having a lot of Latin in it. But there's also a fair amount of French, Norman French, that comes back from the time that, William the Conqueror invaded England in 1066. Well, the winner gets to set up his own courts. And so Norman French was a language of English courts for many, many years. And as a result, we still have some remnants of those French terms. Well, this is an example of that. So we have the grand jury and we have the petit. You can see the word petite or petit in French jury, and you can see this means big and this means small. And the way that the reason that for the difference in the names is the size of the jury, how many jurors are on it. Historically, grand juries had 24 people sometimes on it. They could be very big. Petit juries usually have 6 or 12 people. 6 if it's a relatively insignificant crime, 12 if it's a more serious crime. In Texas, though, grand juries are limited to 12 people. So we've kept the name grand, but we have downsized it. If you were to go to a different state, though, you may find that the numbers are significantly higher. So this is where we get the names grand and petit. Come from these areas. And while I'm making it sound like it's very French, we in Texas just pronounce it grand juries, and this is petit juries. We don't say petite or petit, we say petit. Almost like you're petting an animal, pet it, pet the dog, pet it, is how it sounds. You may have also heard the expression petty juries or petty trials. That's where that comes from. Many times when you hear people talk about that, they will actually spell it this way, petty as in unimportant. Well, it comes from the same petit word. Okay, so let's go through the service that the jurors have to make depending upon which type of jury a person is assigned to. So grand jury members usually serve for a set period of time, a matter of several weeks or even months. And during that time, though, it's not a full-time gig, it's a part-time gig. Maybe they meet one afternoon a week or one afternoon a month. It can vary in terms of the commitment, but it's not a 40-hour deal. With a petit jury, it really is a full-time deal when it is ongoing. Your trial may last only 3 hours and then you're done, but if the trial goes on for 3 or 4 weeks, during those 3 or 4 weeks, you're probably going to be in the courthouse 40, maybe even more than 40 hours. There may be times where you have an afternoon or a morning off, but more often than not, you will be serving in the jury for that period of time. Grand juries also often hear multiple cases. They may be assigned to hear all of the cases from a particular prosecutor for a period of time, and that's very different from a petit jury because a petit jury is just going to hear one case. It's not true, though, that grand juries always hear multiple cases. Sometimes they're assigned to one topic. This is especially true if there's a special prosecutor who's just investigating one issue. You may recall when Robert Mueller was assigned to be a special investigator. Well, he had at least one grand jury that he managed. Sometimes there can be more than one grand jury assigned to a particular high-profile situation. So typically, a grand jury either hears lots of cases, whatever kind of comes down the pike during a particular period of time, or perhaps they may just hear one big case. Another difference between grand juries and petit juries is that grand juries hear only from the prosecutor. They develop usually kind of a close relationship with the prosecutor because he's or she's the only person that they're interacting with. Petit juries, though, hear from both the prosecutor and defense. Obviously, during the trial, you hear witnesses from both sides, you hear opening and closing statements. The judge is also there. And so the petit jury oftentimes looks more to the judge kind of as a source of authority, whereas grand juries are probably looking more to that prosecutor. As a result of hearing only from the prosecutor and not from the defense, it's a little bit like if I were to have my child come in. My child Billy runs in and goes, "Sally just bit my arm. Look, Mommy." And I see teeth marks. At that time, if I only hear from Billy, I'm thinking Sally bit Billy, right? But let's imagine, so that's how it would be if I were on a grand jury. I hear only one side of the story. But if I am on a petit jury, I'm going to hear both sides. So I hear Billy's side. I see the picture of the teeth marks. I hear him testify about Sally biting him. But then I also hear Sally testify, "Oh no, Billy bit himself. You can see where the bite is. It's in a location that he would have been able to put his mouth around that part of his arm." And there are 3 witnesses that I'm going to call who all will testify they saw Billy bite his own arm in an effort to frame me for the arm biting. So now I have a much more complete view of the 2 competing stories. I may believe Billy's story, I may believe Sally's story, but I have a lot more to work with than if I'm just hearing Billy's story. And so that puts a very different spin on the deliberations and the considerations that happen with a grand jury compared with a petit jury. Another big difference is that grand juries are secret. In fact, if you're called to be a witness in a grand jury and you spill the beans about what you were asked, that's actually a crime. And the members of the grand jury also have to keep information secret. You may ask, why is that? Shouldn't we, isn't this the public having a right to know? Well, the idea is that whoever is being investigated in the grand jury hasn't been convicted of anything, hasn't even been indicted yet. And so we could, if we were to allow these matters to become public knowledge, this could cause this person's reputation. Maybe he would lose his job, maybe his spouse would leave him, maybe he would lose his home. And it all might end up being a tempest in a teapot. Maybe there was nothing to the allegations. And so that's one reason why we want to keep them secret. I guess another reason is that whenever you're involved in an ongoing investigation, there can be issues of, people's lives being in danger or a sensitivity about the particulars of the investigation. Maybe revealing this part of the investigation during the early stages might compromise other testimony or cause other people to change their testimony or things like that. Petit juries are obviously happen in trials, and so therefore trials are public almost always. Occasionally, the identity of petit jurors are kept secret if it's a very high-profile matter, but that's pretty rare, and the trial itself is still going to be public. The grand jury, because they deliver the indictment, which has to happen before the trial begins, they work exclusively before the trial. Petit juries obviously work during the trial. I mean, they're the people hearing the evidence during the trial. The biggest difference, though, so far I've talked about some significant differences, but the biggest difference is the grand jury's burden of proof is dramatically lower than the appellate jury would be. So a grand jury is focused on probable cause. Is it more likely than not that the grand jury, or excuse me, that the criminal defendant committed this crime? That's a very low burden. It's especially low when you consider that they only hear from one side, the prosecutor. See, if you only hear from one side and you only have to be persuaded that it's more likely than not, you can see that grand juries are very inclined to indict. So it's a relatively easy thing for a prosecutor to persuade a grand jury to indict. At some point, and another reason why it's easy to get a grand jury to indict is that the vote doesn't have to be unanimous. I think in Texas it only needs to have 9 of the 12 grand jurors vote to indict in order to have an indictment issue. Another term that we see for indictment in Texas is true bill. And many times it's used as a verb. So you might say, the grand jury true billed him. That means the grand jury indicted him. If the grand jury votes not to issue an indictment, we call that no billing. The grand jury no billed Bob or whatever. That means they decided not to indict Bob, at least at this time. Another difference between a grand jury and a petit jury is a grand jury can investigate independently. They can issue subpoenas that maybe the prosecutor isn't even involved with. The petit jury is prohibited from doing any kind of an independent investigation. They can only prosecute, or excuse me, consider the information that they receive from the two sides, the defense and the prosecution. If a juror decides to do some kind of investigation on his own, say Google distances between two locations or something along those lines, that's sufficient in most cases to result in a mistrial. So it's very, very much the case that petit jurors cannot investigate, whereas grand jurors can. Um, and then we had the fact that grand juries apply only in felony cases. In Texas, we have grand juries for state matters and federal matters. All states have them for federal matters, but some states have decided to forego this, the indictment process. The reason that they've foregone is that the indictment process is it's such an easy hurdle to overcome that really prosecutors are usually able to get an indictment pretty much whenever they want it. And so it's a formality that really doesn't accomplish much, except inconvenience the people on the grand jury. As a result, some states have said, this isn't really protecting anybody, we're going to go ahead and eliminate it. But in Texas, we continue to have grand juries, and I haven't heard any talk of eliminating grand juries, so I think we can expect to have them continuing in felony cases, just as we do in the federal court system. Petit juries exist, though, for both felony cases and misdemeanor cases. If you have a misdemeanor, obviously there's not going to be an indictment before it. We call the document that precedes it, that's kind of the equivalent of an indictment, we call it an information. Um, but again, we have both misdemeanors and felony cases in front of petit juries. Let me talk a little bit about double jeopardy, because this can be a little tricky. You may have heard of the term double jeopardy. Let me just refresh you on what that means. So jeopardy attaches for a criminal defendant when he or she is being tried for a crime. And let's say that person ultimately is acquitted of the crime. But 2 years later, smoking gun evidence is discovered that make it really, really clear that in fact this person did commit the crime. They got away with it. And so now the prosecutor wants to recharge that person for the same crime. But you can't do it. You can only charge somebody once for a crime. Once jeopardy attaches, that person can't be prosecuted for exactly the same crime again because of the double jeopardy protections in the Constitution. When jeopardy exactly attaches is a really complex issue beyond the scope of this class, but it definitely doesn't attach during the grand jury process. So someone can be indicted again and again and again for the same crime, and there's no issue about double jeopardy somehow stopping that process. Even trials can begin. Let's say the trial just begins. It's the very first 10 minutes of trial and something happens which causes a mistrial. Well, again, there isn't a problem. Jeopardy hasn't attached yet. But at some point during the petit trial, or during the trial that the petit jury is seated in, jeopardy will attach. And after that point, it won't be possible if the petit jury acquits for that person to be retried. So again, don't worry about knowing exactly the moment where jeopardy attaches. Just know it attaches during the trial, but it doesn't attach during the grand jury proceedings. So now we've covered the differences between a grand jury and a petit jury. Please be familiar with these, at least enough to recognize them and to be able at least to recall several of the differences between grand juries and petit juries, because you'll need to do so on the test. Thank you so much for your attention and have a wonderful day.